So, welcome to the South Asia final of the 22 FDI moot. We will be hearing Team Mawdsley against Team Fitzmaurice. We have a tribunal composed of Mrs. Funke Adekoya, Senior Advocate of Nigeria, one of the leading independent arbitrators worldwide, and especially in Africa, former founder of one of the leading law firms in Nigeria. We have Mr. Amr Abbas, a partner at Matuk Basuni and Hanawi, and head of international arbitration there, as well as a member of the faculty at Cairo University. And presiding, we have Ms. Smithri Bhaskar, Senior Research Fellow at the Center for International Trade and Investment, established by the Government of India. And I'm also happy to say one of the designers of this year's FDI moot case. With that, I'm going to turn off my camera and microphone and turn it over to Smithri Bhaskar, please.
Thank you, Chris, and welcome all. Before we begin, can the teams confirm if they have agreed on an order of argument and a time split between their speakers?
We have, Madam President. We have agreed to follow the RCCR procedure, respondent procedure, followed by claimant procedure, then moving on to claimant merits, followed by respondent merits. The respondent speakers will be taking 19 minutes each for their arguments and reserve 1 minute each for their rebuttal and sur-rebuttal respectively. And we'll put that up on the chat box as well for your convenience.
Great, thank you.
And Madam Presiding Arbitrator, the claimants will be following a 19+1 format for the procedure and a 20+1 format for the merits.
If I could request you to also put it up in the chat,
yes,
so we can have some record. Thank you so much. I think without further ado, we can start with hearing Sutton Holdings versus the Republic of Czechia, unless my co-arbitrators have anything they would like to add right now.
Nothing from me, Madam Arbitrator.
Thank you.
Good day, Madam President and members of the tribunal. I am Rohan Singh, and I represent the respondent in this proceeding, the Republic of Czechia. Today, I will address the procedural issues before us. The present dispute is merely an attempt by a calculating and scorned investor to blame the state for its losses. It is a claim that is fit to be nipped in the bud, because in their eagerness to get money from Czechia in any way possible, the claimant has forgotten to meet basic jurisdictional requirements. Members of the tribunal, I submit that the tribunal does not have jurisdiction to hear the present dispute because of two reasons. Number one, because the government has failed to comply with Article 12 of the BIT, and it has not sought local remedies in the domestic courts of Czechia before initiating arbitration. And number two, because the present claim is barred by the doctrine of res judicata. Members of the tribunal, even one of these reasons is sufficient for the tribunal to hold that it does not have jurisdiction over the present dispute. If there are no preliminary inquiries, I would like to move to the first issue concerning local remedies, wherein my argument is made up of two limbs. One, the claimant has failed to comply with Article 12, and number two, that the claimant is not entitled to any exception in this regard. Coming to the first limb, I submit that as per Article 12 of the Athabasca Czechia BIT, it is mandatory for an investor to first seek remedies in domestic courts before initiating arbitration. This condition is exactly in line with Article 26 of the ICSID Convention. Members of the tribunal, it is a matter of record that the claimant has not followed and not complied with Article 12. And in order to submit this, I invite the attention of the tribunal to page number 65 of the record. That would be page number 68 of the PDF. On the hard copy, it is page number 65. If the members of the tribunal are with me, these are uncontested facts, and I quote from paragraph number 50. To date, the claimant has not commenced any claim in the domestic courts of Rikia. Thus, the claimant did not even attempt to submit a dispute to courts, let alone for a period of 18 months that is mandated by the BIT. To escape this fundamental flaw in their case, the claimant has invoked the futility exception. For the futility exception to apply under international investment jurisprudence, it has to be proved that there is no reasonable possibility that a case could have been decided in the given time frame. This is known as the reasonable possibility test. The claimant is exactly arguing this. They are contending that there was no reasonable possibility that Rakian courts could have given a decision in 18 months. However, this is factually untrue. The said exception does not apply here, and this is the second limb of my argument in this issue. There was a reasonable possibility indeed that Rakian courts could have heard the matter and decided it within 18 months, and the claimant should have first approached Rakian courts. The foremost evidence of this is the fact that Donald and Daisy, the controlling shareholders of the present claimant, brought a claim before the local courts of Rakia in the year 2016 itself. And in 2016, while the civil war was still going on, the local courts of Rakia decided that matter in a mere 12-month period, after which Donald and Daisy initiated arbitration in 2017. Thus, a period of 12 months was indeed possible to decide a case. Now in 2022, the claimant is before us saying that the dispute could not have been settled in 18 months when the courts in Rakia have been functioning smoothly since the civil war ended. And in order to submit this, I would like to invite the attention of the tribunal to page number 90 of the record. That would be page number 93 of the PDF. And if the tribunal is with me, thank you. I would like to quote from the last line on page number 90 of the record, the last line of paragraph number 9. As of January 2021, the average time for a case to be heard at the first instance was 12 months. Thus, it was not futile for any investor to approach the courts, since there was more than a reasonable possibility that a case could have been settled in 18 months alone. The tribunal should note that the claimant has refused to approach domestic courts, contending that 18 months is insufficient. However, the claimant has only initiated this arbitration after 4 years from the point in which the civil war ended. They did not bring any claim for 4 years. This shows that they were in no hurry to arbitrate. They had more than enough time to submit their dispute to a local court and obtain a relief, even if it took more than 18 months, because they have already waited much more than 18 months anyway. They have waited around 48 to 50 months before initiating anything against the state of Rakia.
Counsel, just a question. You submit that the exception applies, but the conditions do not apply. So there is an exception to the rule, but only the conditions will not be not accepted.
Indeed, Mr. Arbitrator, there exists a futility exception under customary international law, but the threshold in order to attract that exception has not been met in the facts of the present case, because the case could have been decided in 12 months alone, let alone 18 months. So Madam President, do I sense a concern?
Yes, I have a question on the fact that you just read out on the 12 months. In my understanding, it is that it takes 12 months for the case to be heard in the first instance. Is that equivalent to a resolution of the dispute, firstly? And secondly, if it takes 12 months to hear the dispute at the first instance, is it reasonable to expect it to be resolved in the following 6 months?
Thank you, Madam President, for your question. So, as per the case of Ambiente Officio versus Argentina and the case of Urbasser SA versus the Argentine Republic, it has been held that in BITs wherein a time-limited pursuit has been mandated and a time period has been given after which an investor can bring a claim to arbitration, the onus is only to approach a first instance court. It does not mean that the party is bound to keep appealing till the highest court of authority. And thus, the claimant was bound to approach a first instance court and obtain and pursue proceedings for at least 18 months before initiating arbitration. In the facts of the present case, the claimant was indeed entitled and should have approached the one local courts. And Madam President, if I may request you to please repeat the second part of the question.
The second part of the question was that if it takes 12 months to hear the dispute at the first instance, is it reasonable to expect it to be resolved in 6 months following that?
Indeed. There is no onus that the claimant keep pursuing the case and expect it to be resolved in the remainder of the 6 months. Because even if the case is not resolved in the remaining 6 months in a higher court, they would be empowered to bring a claim after 6 months without receiving a relief. Which brings me to Article 31 of the VCLT, and wherein we have to understand the purpose behind which Article 12 has been included in the present BIT. The purpose behind Article 12, in order to first seek submission to local courts, is so that a host state should at least have the opportunity to first resolve a dispute before its local courts, before being forced to assume responsibility in an international forum like the present tribunal. Because there exists a possibility that the local courts of a country would grant the investor the very relief that it is seeking in the time frame, and the dispute would be over in that time period itself. And thus the state would be saved from going to an international arbitration. And thus, we submit that depriving Rekia from the opportunity to address this dispute locally would go against the very spirit of the BIT. If there are no further questions in this regard, I would like to move to the second issue concerning res judicata. Res judicata, or claim preclusion, is a general principle of international law. It bars the relitigation of claims between the same parties for the same type of relief and relying on the same legal arguments. These are the three essentials of res judicata. Members of the tribunal, the claimant herein is a joint stock company with a controlling stake being held by two people, Donald and Daisy. Donald and Daisy have already brought an arbitration claim against Rekia in 2017 for our actions in the civil war. It is our case that these very people, Donald and Daisy, now want to sue Rekia again for the very same conduct through the company in which they hold a controlling stake. Before moving to the essentials of res judicata, I would like to highlight that the previous award rendered in the Donald and Daisy case has not been annulled. Thus, it is binding on the parties. This brings me to the first essential of res judicata, that the parties in both proceedings must be the same. The question that naturally arises before us is whether the controlling shareholder of a company and the company under his or her control are the same party. We submit that indeed the controlling shareholders are the same as the company that they control. And for this, we rely on the economic approach of looking at parties. The economic approach flexibly categorizes a group of affiliate entities into the same party. This approach has been favored by multiple awards. One such award was in the ICSID case of Orascom versus Algeria. The tribunal in this case dismissed an investor's claim as it was brought by the same investor who had brought a separate arbitration against the same state but through a company in which it had shareholding. The tribunal found that the investor and the company were the same as they had the same economic interest. Members of the tribunal, I urge you to note that our case is highly similar to the Orascom case, as Donald and Daisy and certain holdings have the same economic interest, and Donald and Daisy have a 75% controlling share in certain holdings. This economic approach, indeed, Madam.
I'm sorry, very quick question. In the case you just cited, what was the shareholding percentage of the investor?
In this case, the shareholding was a minority shareholding, Madam President. And yet the tribunal held that it would amount to an abuse of rights if the same interests are represented again. In our case, the interest is a controlling share interest and not a minority one. Moving on, I submit that even the very BIT under which we are here envisages that controlling investors of a company are the same parties as the company that they control. And in order to submit this, I would like to invite the attention of the tribunal to page number 79 of the record. That would be page number 82 of the PDF. If the tribunal is with me, thank you. I would like to quote from Article 13.7. The contracting parties recognize that under this article, minority non-controlling investors have standing to submit only a claim for direct loss or damage to their own legal interest. Thus, the BIT itself makes a distinction between minority non-controlling shareholders and majority controlling shareholders. While minority shareholders are only empowered to bring a personal claim, the majority controlling shareholders are empowered to bring a claim on behalf of the enterprise. It should be noted that this is also the prerogative of the company. Thus, the BIT envisages that what the company can do, the shareholders can do just as well. They have been put on the same pedestal following the economic approach because the controlling shareholders control the company and have the same power under the BIT. With this, I urge the tribunal to follow the economic approach that has been envisaged in the BIT and hold that Donald and Daisy are the same party as the company that control certain holdings. Indeed, Madam President.
Mr. Singh, if I could interrupt you at this point, are you saying that despite the difference in language between the English version and the Rekian version of the BIT, that the parties still remain the same?
Indeed. Madam Arbitrator, that is a very relevant question. And I must point out that both language versions of the BIT empower the controlling shareholder to bring a claim on behalf of the enterprise. That is, under both language versions of the BIT, the controlling shareholder has the same power as the company that it controls. And thus both BITs put the controlling shareholders and the company on an equal pedestal, envisaging them to be the same party. And that is why we urge that there is no discrepancy when it comes with regard to the identity of parties between the BITs. And thus, both of them should be considered to be the same party. Moving on, I submit that the other two essentials of res judicata, the same cause of action and the same object, are also met. The cause of action in both the cases is the same. That is, Rekia's actions in the civil war. Even the BIT is the same. The claimant here is likely to argue that they are not looking for the same relief, that the first claim was for reflective shareholder losses and the present claim is for direct damages to the investment. However, they would be using a tactic which is called claim splitting, wherein parties like the claimant divide their claims to relitigate the same cause under the guise of different reliefs. The International Law Association recommends an autonomous approach that prevents claim splitting. In its final report on lis pendens and arbitration, the International Law Association defines the autonomous approach as such, and if I may quote, an arbitral award has preclusive effects in the further arbitral proceedings as to a claim, cause of action, or issue of fact or law which could have been raised, but was not, in the proceedings resulting in the award. Thus, a relief that could have been raised earlier, should have been raised earlier, or otherwise it would have preclusive effects. This is so because multiplicity of proceedings has to be discouraged. Redundant proceedings have to be discouraged. This is also enshrined under the general international law principle of collateral estoppel, which has been adopted in cases like Petrobras Limited versus the Kyrgyz Republic, wherein parties which were empowered to raise certain claims and reliefs in the previous proceeding were held to be liable and bound to have raised those issues in the previous proceeding itself. They were prevented to seek a relief that could have been raised earlier in the subsequent proceeding. I submit, members of the tribunal, that the claimant is now bringing the very same claim that could have been raised earlier. As I submitted, both language versions of the BIT. Do I sense a concern, Mr. Arbitrator?
Just one question here, counsel. Is your argument is that they are raising the same claim, or that this is a different claim that they should have raised, but they have not?
The claim is prima facie different, but it is a related claim that could have been raised in the previous dispute. And under the autonomous approach, as well as the principle of collateral estoppel, claims that could have been raised earlier should have been raised earlier. If I may seek an extension of 60 seconds to sum up my arguments, as I have.
Sure.
Thank you, Madam President. It has been held that, as I've argued, that Donald and Daisy were empowered to bring the very claim that the claimant is bringing now. Even the previous claim that they brought was under Article 13(2)(b) of the BIT, and it was on behalf of the enterprise, Southern Investment. The present claim is also on behalf of the enterprise, Southern Investment. So nothing prevented the controlling shareholders from seeking this very relief in the previous arbitration. Whether Rikia as a state breached the BIT and owed any damages was already being contested there. Any relief arising from this question ought to have been asked at that stage under the general international law principle of collateral estoppel, and as per the opinion of Professor Schroer and Reinschach in the case of CME versus Czech Republic in their legal opinion. With this, I come to an end of my submissions. It was an honor to argue before the tribunal. Thank you.
Thank you, counsel. If there are no questions, then we can have the next speaker.
No questions from me, Madam Chair.
None from me as well. Thank you.
So invite the claimants.
Thank you, Madam Presiding Arbitrator. Before I begin, if I may inquire, I am fairly audible to the tribunal.
Yes, Your Honor.
Thank you. Madam Presiding Arbitrator, members of the tribunal, good evening from this side of the world. My name is Sarthak Raj. Along with my co-counsel, Mr. Yashwant Sanjanbam, we have the honor of representing the claimants today, which is Sutton Holding Incorporated in the present proceedings. Before I dive into the allegations made by the respondent and respond to each query, allow me to frame the main crux of the matter today, which is with regards to the admissibility concerns and not the jurisdiction concern. The first issue raised by the respondent, which is with regards to the exhaustion of local remedy clause, is an issue of admissibility and not an issue of jurisdiction. And simultaneously, the issue of the doctrine of res judicata is also an issue of admissibility and not an issue of jurisdiction, for the reason that the question is not with regards to the selection of forums, but rather the only concern that the respondent has today is that the same claims should not be relitigated again in the present proceeding. Now, with that, I would like to respond to the respondent one by one. Firstly, with regards to their concern of exhaustion of local remedies. Members of the tribunal, the respondent has quite rightfully relied on Article 12 of the BIT, which is in particular the paragraph 2, which states that there should be a requirement of 18 months of exhaustion before invoking the arbitration proceeding. And for that, they have brought a similarity between Article 26 of the ICSID Convention. Now, since the respondent has themselves brought up the Article 26 of the ICSID Convention, the commentary to Article 26 of the ICSID Convention by Mr. Schur clearly states that the futility exception is a complied binding obligation within the exhaustion of local remedies. Now, in that situation, if there exists and the requirements of futility exceptions are fulfilled, then in that situation, the party is not required to exhaust local remedies, be it of 12 months, 18 months, or 24 months. Now, in the present case, the time limit is that of 18 months. However, if we are to look into the futility exception, which is in particular provided by Mr. Dugard in the Special Rapporteur to International Law Commission in its report of Article 15 of the draft article on diplomatic protection, which provides for 3 reasonable prospects. First, that there should be a reasonable possibility to redress the claims of party. Second, there should be an undue delay on the part of the party. And third, there should be a denial of justice. Now, we do not contend that there was a denial of justice. However, we contend on 2 limbs. First, that there was no reasonable possibility on the part of the claimant to redress their claims. And second, that there was an undue delay on the part of the respondents' local courts. Now, as regards to the reasonable possibility, I will show it to the tribunal that the situations were very worse and the claimants could not have claimed their claims in the domestic courts. However, in the present case, respondent has very well come here and stated that the Daisy and Donald Award was delivered within 1 year and in 2016. However, they have not covered the entire set of facts, and it is in that regard, if I may kindly refer this tribunal's attention to page 64 of the case file, and if I may have the tribunal's attention. Page 64, paragraph 46 in particular, members of the tribunal. The first line, as it reads, the situation deteriorated further by December 2016. The Rakian authorities' intelligence units had picked up a possible bomb threat, and then on the subsequent line on the same paragraph, it says that they had temporarily barricaded the Rakian Supreme Court and ordered the immediate cessation of all physical operations. Members of the tribunal, it is to be taken into consideration that the Donald and Daisy Award came even before the situation in Rakia deteriorated. And after the deterioration of award, the physical hearings were closed and everything was turned into virtual mode. Furthermore, if I may kindly refer you to the next page, that is page 65 of the case file, at paragraph 48 in particular. In the same paragraph, it also states that there was a civil unrest and there was an increased case load on the courts of the Rakia. Now, similarly, the next paragraph, that is 49, it says on the last line that the typical time to be heard at the first instance was between 16 to 18 months after it first commenced. Now, although the respondent has very rightfully came here and directed the attention of the tribunal to the procedural order 3 and stated that the time has been reduced to 12 months. However, members of the tribunal, 12 months is still 2/3 of the exhaustion time that is provided in the BIT, which is 18 months. And for an investor who has suffered major losses in the hands of respondent state, it is not viable to wait for 12 months to only redress their claims at the first instance and then wait for another long time period to even have a judgment at the first place. Therefore, it was not...
What do you say for the fact that you waited 4 years to commence this arbitration? So what about, it wouldn't matter if you wait another 18 months?
I understand your concern, Mr. Arbitrator. However, there was a series of actions, and it was not only 2016 that everything ended for the claimant and respondent. After the certain plans were destroyed, the armistice took place, and even post that, the claimant suffered major losses in the abroad market, as well as in the form of sabotaging of the fresh equity offers. So there was a series of actions that took place from 2016 to 2020, and that is what led claimant today to bring a proceeding on behalf of the certain holdings, that there has been claims arising out of not only the harm or the failure of the respondent state to protect certain plants, but also the very action of sabotaging the reputation and credit of the claimant, as well as the mental duress that the employees have suffered. Therefore, the 4 years of time period, which is taken as an umbrella to cover up the inessential or the reasonability of the Rakian domestic courts, it is to be taken into consideration that the domestic courts were not adequate enough to possibly redress the claims of the claimant, and therefore there was no requirement for the claimant to even approach to the courts of the Rakian authorities. Moreover, they have relied on Article 31 of the Vienna Convention on the Law of the Treaties to state the very purpose of Article 12 of the BIT. Now, members of the tribunal, Article 31 of the Vienna Convention requires the parties to interpret it in good faith, along with the purpose and object of the treaty. Now, in that regard, if I may kindly refer this tribunal's attention to the preamble of the BIT, which may be found at page 72 of the case file. The preamble in itself on 2nd and 4th clearly states, recitals clearly state that the whole objective of the BIT is to protect the investment and therefore the rights of the investors. Now, if we are to read Article 12 as a mandatory obligation with the futile remedies available in the Rakian Code, it would subdue the very essence of the preamble of BIT, which is to protect the investor and the right of the investors. Therefore, as a prudent investor, the investor was not required to wait for 18 months and approach the domestic court, which could not have redressed the claims of the claimant. And therefore, even under the purview of Article 31 of Vienna Convention, the futility exception stands and does not prohibit the respondent to bring such a claim to the exit tribunal today. Now, with that, I would like to move on to the second claim, which is with regards to the res judicata. Now, members of the tribunal, the whole case of the respondent with regards to the res judicata stands on one major word, which is controlling shareholder. Members of the tribunal, it has been very wrongly misinterpreted before the tribunal with regards to what a controlling shareholder is and what the Daisy Donald actually is in the present case. And in that regard, if I may kindly refer this tribunal's attention to page 66 of the case file. In particular, paragraph 56, whenever the tribunal is with me, the second last line as it reads, in particular, Donald and Daisy held 75% of all shares in the Sutton Holdings, of which 30% was owned by Donald and 45% was owned by Daisy. Members of the tribunal, there is a very thin line between the ownership and the control of the shares in the company. And as defined by Aaron Broches in the exit convention, the ownership in a company and the controlling aspect in a company are two different altogether. And therefore, a owning shareholder cannot be said to have been the driving factor in a company or a controlling factor in a company. Therefore, the three-part test as proposed by the respondent themselves is one, that there should be an identical party for res judicata to apply. Second, there should be similar factual matrix between both the proceedings. And third, the ground or the relief of both the proceedings should be similar. As regard to the first part, that is the identical parties, members of the tribunal, we are to take into consideration that they have they have relied on the case of Orascom versus Algeria. However, members of the tribunal, Orascom versus Algeria is a case of a parent company and a subsidiary company, and not a company where the shareholders had brought a claim and the same claim was tried to be imputed on the corporate entity. Therefore, a claim of a subsidiary company can be imputed to a parent company, but the claims or a proceeding or an award which has been delivered onto the owner of the shares of the company, who are not the controlling shareholders of the company, cannot be imputable to a corporate entity. Moreover, the minority shareholder, yes, ma'am.
I can ask a question. I think the respondents also alluded to an economic analysis or an economic test. And while I understand you're differentiating between ownership and control over the company, would not mere ownership also, since it's such significant ownership, be sufficient to satisfy the requirements of that test?
And also, before you answer that question, could you also, as part of your answer, please indicate whether there's anything in the record that shows that the majority shareholders were not the controlling shareholders?
Certainly, Madam Arbitrator. Answering to Madam Presiding Arbitrator's question first, the minority shareholding or just the owner of the owner holding of the company cannot be said to have the rights, or where such claims have been brought by them in the past. Such claims cannot be imputed to the corporate entity in the present case because of two reasons. One, that it was held in the Esposol versus Italy by the ICSID tribunal itself, that the shareholders who do not inform the corporate entity about any proceedings that has been carried out in the past, such proceedings cannot be brought in later as a part of res judicata doctrine and cannot be imputed on the corporate entity. Now, in the present case, the party was never aware, the claimant was never aware of such a proceeding carried out by Daisy and Donald. And in that regard, if I may kindly refer this tribunal to page 91 of the case file. Whenever the tribunal is with me, a particular paragraph 16 states that Donald and Daisy initiated a claim for their shares alone and did not communicate or consult with certain investments. Members of the tribunal, it is very evident that the claimant and Daisy and Donald are two separate entities, and this is even recognized under the concept of the separate legal entity, which is recognized in the CME versus Czech Republic by the ICSID tribunal itself. And moreover, because there was no consultation and flow of information between shareholders and the entity, therefore, such cannot be imputed to the corporate entity. Now, as regards to Madam Arbitrator's question as to if there is any evidence in the case file with regards to the controlling aspect, Madam Arbitrator, there are none in the present case. However, the only evidence that is available in the present case is with regards to the ownership of shares by Daisy and Donald in the certain holdings, which is 45% and 30% respectively. And therefore, such cannot be subsumed to be the controlling shares of the company itself. Now, moving on to the last two limbs, which is one, the factual matrix and the ground relief. I would merge them together and address it for the tribunal's perusal. And in that regard, if I may first take your attention to page 6 of the case file, which is notice of arbitration. Paragraph 25 in particular, members of the tribunal. It reads that due to Rekhia's deliberate inaction in trying to stop the armed conflict directed at certain production plant, the claimant's assets have been fundamentally impaired. Now, the claim that the claimant has brought today is with regards to the claimant's assets because of the harm caused to the certain plants. Now, with regards to the Daisy and Donald, if I may kindly refer this tribunal to page 32 of the case file. In particular, paragraph 6, whenever the tribunal is with me. Now, paragraph 6 in particular provides that during the civil uprising, it was the share prices, the decrease in the value of shares, And Donalds and Daisy had filed this case only because there was a drop in the reflective shareholder rights, and their act and commission had a causal impact on the shares and the rights as shareholders. Now, both the cases are entirely different in a manner that one, the claimant, Sutton Holdings, is claiming here is with regards to the Sutton assets that has been impaired out of the attacks by armed militia and the failure of respondent state to preserve. And second is the claim brought by the Daisy and Donald in the past with only regards to the drop of share price and the loss of shareholder rights in the company. And the relief sought was one with regards to expropriation in the Daisy and Donald and the compensation for expropriation, whereas the relief sought in the present case is with regards to full protection and security and the material and moral damage flowing out of the same. It is in that regard we submit before this tribunal that the res judicata doctrine has not been fulfilled, and the burden still stands on respondent to prove that one, both parties are not just similar parties but identical parties. Second, the factual matrix are exactly the same. And third, the ground or the relief is exactly the same. With that, I thank the tribunal, and I would like to
One question, counsel. If
Yes.
the shareholders in Daisy case have won, would you still have argued that you still can move on and file this case?
Certainly, Mr. Arbitrator.
So in that case, you will get compensation for the expropriation and also another compensation under the full protection of doctrine, and under both you will get here compensation and here compensation. Will you consider this a double compensation?
Certainly not, Mr. Arbitrator. The compensation claimed by Daisy and Donald is for the Daisy and Donald's benefit itself, that is the shareholders' benefit, whereas the compensation here is for the entity's benefit and the assets, not just the drop of price of the shares that the Daisy and Donald has claimed. So these are two different compensations.
Would not the drop of share value be related to the value of the asset, the underlying asset of the company as a result of the civil unrest?
Madam Arbitrator, I sense my time is up. If I may answer your question in another 30 seconds.
Yeah.
Thank
Please.
you, Madam. Madam Arbitrator, the computation of compensation in the present case with regards to the material damage may take into consideration the share prices. However, the question here is not with regards to whether we are asking punitive damages or the double the damage as a comparison to Daisy and Donald award. However, rather the question here is whether the factual matrix and the intention of the party in both the cases are same. It is not. The Daisy and Donald only related to the shareholder rights, whereas Sutton Holdings here stands for the harm caused to the assets of the company, and the primary question or the compensation is with regards to the assets of the company. With that, I thank the tribunal.
Thank you. Thank you. I think we will now move to rebuttals and rebuttals, if any, for the procedural issues. If I can invite the respondents.
Thank you, Madam President. In response to the arguments raised by the claimant, I have twofold rebuttals. Number one, that the claimant is saying that there was no reasonable possibility that the courts in Zekia could have resolved a dispute in 18 months. Yet at the same time, they are admitting that in 2021, when they brought the present claim, the time that would be taken was only 12 months. Thus, when they brought this arbitration in 2021, they were required to approach the courts in 2021. Applying a futility exception here would go against the very intention of the drafters to have some time before an international arbitration is invoked against them. Secondly, the previous arbitration was invoked on behalf of the enterprise Southern Investment. This present arbitration has also been invoked on behalf of the enterprise Southern Investment under Article 13(2)(b). The relief sought under the principle of collateral estoppel could have been sought in the previous arbitration and should have been asked in the previous arbitration. Thank you.
Thank you, counsel. If I can invite the claimant to respond if they want to.
Madam Arbitrator, I have one point of rebuttal to the respondent submission. And it is only with regards to the parties to both the proceeding. And one need to understand that the award that was decided in Daisy and Donald was erroneously decided for the reason that it was based on a Rakian version of the BIT and not the English version of the BIT. And why the English version of the BIT should exist at the first place as the dominant or the authoritative text is because it is annexed as a translated language at the end of the BIT, which is provided at page 87 of the case file. And therefore it serves as an authoritative text, and the award is null and void in the Daisy and Donald case. With that, I thank the tribunal.
Thank you, Counsel. We can now move to the merits of the case. I invite the claimants again to come back if my co-arbitrators have nothing to add at this stage.
No questions.
No questions, Madam Chair.
Great. I invite the claimants to come in with their merits arguments.
Greetings once again, Madam Presiding Arbitrator and members of this tribunal. As already introduced, my name is Mr. Yashwant Sanjanbam, the second counsel for the claimants, Sutton Holdings Incorporated. And in today's proceedings, I will be doing my utmost best to assist the tribunal in deciding three main issues. Firstly, is whether the respondents has violated the full protection and security standard, hereinafter referred to as the FPS standard under Article 5 of the BIT. Second, whether the claimant is entitled to compensation under the War Losses Clause under Article 6 of the BIT. And third, whether the claimant is entitled to moral damages. Starting with the first main issue, if I may refer this tribunal for its convenience to page 75 of the case file. That's page 75.
Yep.
The tribunal will find Article 5 of the BIT. Now, the first question before this tribunal with regards to the violation of the FPS standard is what exactly is the standard of liability? Now, in this regard, the tribunal will see that Article 5 has two clauses. And in these subsequent clauses, we have two references to two specific phrases. The first clause mentions international law, and the second clause in its fifth line mentions international law minimum standard of treatment. Now, what do these two phrases mean? It is the claimant's submission based on the decision held in AAPL versus Sri Lanka and Cengiz Insad versus Libya that these phrases are a reference to customary international law. So the pedestal or the standard for the FPS obligation is CIL. What exactly follows is the duty of protection of FPS standard under the CIL, and it is our submission based on the decisions of the earlier stated cases that it is the duty of due diligence. Now, at the offset, members of this tribunal, the respondents may come forth and state that the threshold for such an obligation is relatively low. And in response to that, the claimants would like to agree and submit that indeed it is a low threshold that must be met. However, in spite of such a low threshold, the respondents have still failed to uphold the FPS obligation. Coming back to the duty of due diligence, members of this tribunal, the duty of due diligence is separated into two major obligations. The first is a positive obligation, and the second is a negative obligation. Now, what do these obligations mean? The positive obligation is to ensure that the respondent state or the acting state takes up preventive measures to ensure the protection of the investment. And the negative obligation means that the host state must ensure or abstain itself from directly causing harm to the investor's investments. Now, in this regard, what exactly is the factual matrix and the relevance of these two obligations in our present case? The counsel would like to refer the tribunal to the uncontested facts, specifically page 63 and page 64. Whenever the tribunal is with me. Yes. We see on both respective pages the events that took place in the Freya facility and the Odin facility. We first address the situation that took place in the Freya facility. Now, as a result of the civil war that started in 2016, members of this tribunal, the Freya plant was invaded and destroyed by a group of few and sparse armed militia on the 23rd of June 2016. Now, the question is, how exactly have the respondent state failed to protect such a plant? The respondents might come up and say that they have formulated or deployed a military unit within 48 hours of the attack that took place. However, if we look into the deeper meaning of the facts itself, we can see that the exact amount of time it took for the respondents to deploy such a military unit was 2 years and 48 hours, give or take. In reference to this, if I may quickly refer the tribunal to procedural order number 3, specifically page number 91. And specifically, paragraph 13 of page 91, we see that the facts say Sutton Investment CEO, Mr. Ned Flanders, wrote several requests for assistance to the Rakian government, including letters addressed to Mr. Rokhari since the beginning of the conflict in 2014. As we see from the facts of the case, the request to assist the claimants with assistance, whether it's military or otherwise, was sent by the CEO back in 2014, 2 years before the attack on Freya plant took place. And as such, preventive measures could have been taken at the initial point that the request was sent. There's our submissions that the respondent has failed to uphold the positive obligation. Now, yes, Mr. Arbitrator.
Your submission is that by the request, the obligation of the respondent has arisen just by the request, or they have some discretion on when to respond to this request?
Mr. Arbitrator, it would be the former. Now, the duty of due diligence and with regards to the duty to protect the FPS standard is anyways a relatively low standard. It's not an absolute strict liability. We do not expect the respondents to be on guard at the plants 24/7 throughout the clock. All we ask for from the respondents is to show a concerned attitude towards the protection of these investments. And since these requests sent in 2014 was never responded to, the respondents have clearly failed to uphold the positive obligation under the duty of due diligence. Yes, Madam Presiding Arbitrator.
Is there any way that a tribunal or anyone looking at this case would take into account the relative ability of the respondent state in its military actions?
My apologies, Madam Presiding Arbitrator. If you could please repeat the question.
When we consider the FPS standard, do we also take into account the relative ability of the respondent state in its military actions or in taking any military decisions?
Yes, Madam Arbitrator, the development of the respondent state should be taken into account. However, the claimant's submission is that despite of the quote-unquote developing nature of the respondent state, they still have an obligation to, at the very least, be concerned of the protection of the investments. The preamble of the BIT itself states in its second recital, transparency. Now, Article 5 read along with the preamble would then result in a transparent form of communication between the respondents and the claimants. But since none of these took place within the facts, the respondents have failed to uphold such an obligation. Now, moving on to the events that took place in the Odin facility and keeping in mind the negative obligation, which is to abstain oneself from directly causing harm to the investment. Now, the events that took place, to sum up for the tribunal's convenience, is that after the failure of the armed military to protect the Freya plant, the military force requisitioned the Odin facility, which is in itself an illegal act, which the council will be dealing with in its further issues, and stationed within the territory of the plant for a total of 3 to 4 months. And at the end of 3 to 4 months, the decision was taken by the Rakian government to ultimately destroy the plants themselves. Now, what was the reason behind such an order? The rationale of the Republic was that the plants contain certain agricultural sources of food production. We do not contest against this. However, even if the respondent states come out and say that there was a need for such a decision to have taken place, or invokes the doctrine of necessity, it is our submissions that there are certain grounds that need to be fulfilled with regards to the doctrine of necessity. Now, in this regard, the council would like to cite first an ICJ case, Gabčíkovo Nagimarus, and second, an ICSID case, Impreglio versus Argentina, which referred to the ICJ case in its decision. Now, what happened in the Impreglio versus Argentina case was that the grounds of necessity, which includes two major categories. First is a grave and imminent peril against an essential interest. And the second is that the party invoking a plea of necessity must not have contributed to the situation, and the measure taken must have been the only possible way. With regard to the first ground, we do not contend against the grave part of the threat, and our militia in any circumstance will be a grave threat. However, we would like to focus on the imminence of that peril. Now, imminence, as provided in the yearbook of the ILC, 1980, volume 2, has stated that imminence is synonymous with the words immediacy or at the exact point in time. Now, as the council has already stated, it took 3 to 4 months for the situations at Odin to conclude. There was no such imminent peril that took place in the Odin facility. Now, coming to the second ground, which is that the party invoking must not have contributed to the situation at hand, and they must have been the only possible measure that the respondent state took. Now, the council may go along the route to say that the party invoking the plea of necessity contributed to the situation by pointing out to the fact that the respondent state first increased security forces back when the civil conflict started and then subsequently retreated them, which completely destroyed the civil sanity of Reykjavik. However, the claimants would like to give the respondents the benefit of the doubt and that such measures were well-intended but ill-conceived government policies. We would instead like to focus on the only alternative measure available. At the end of these 3 to 4 months, members of this tribunal, the facts clearly state that there was a significant slowdown of the progress of the armed militia. This was the golden opportunity for the respondents' military to have taken a number of situations instead of arbitrarily destroying the plants themselves. They could have reinforced the defenses, they could have secured more perimeters around the Odin facility, and an important point for the tribunal to note is that the soldiers were airlifted at the end of these 3 to 4 months. If such a facility to airlift soldiers was available to the respondents, surely a facility to airdrop resources was also available. But since none of these decisions or none of these alternatives were even considered in the first place, the respondents have violated the negative obligation, and it is our submission that the present dispute is a very simple case of cruel irony, wherein the forces that were expected to protect the investments were the ones to ultimately destroy it. Coming to the second limb of my submissions, as well as the third limb of submissions, which constitute whether the claimant is entitled to compensation under Article 6 of the BIT. Now, once again, for the convenience of this tribunal, the council would like to refer you to page 75 of the case file. The tribunal will find the mentioning of Article 6, and whenever the tribunal is with me, thank you very much. We have 2 clauses once again. Now, the first clause is the clause that provides for the standard for such compensation, and the second are the grounds. Now, at the offset, the council would like to deal with the first clause. If I may point the tribunal to the 5th line of the first clause, the tribunal will find the phrase "no less favorable treatment than." Now, the respondents' counsel may come forth and argue that this is a shield that precludes the respondents from giving any compensation, as no other investors in the present dispute has been compensated. However, the council would like to refer this tribunal to the CMS versus Argentina case, wherein such a clause was mentioned in Article 4, Clause 3 of the Argentinian versus United States BIT. Now, the interpretation made by the tribunal in that case was that this is merely a floor treatment, an insurance that no derogation of treaty rights will take place, and in case any compensation has to be paid, it must be done so in a non-discriminatory measure. Therefore, this clause is just a guarantee that no non-discriminatory measures will be taken and not a shield to preclude responsibility from compensation. Now, coming to the second clause, members of this tribunal, the grounds for compensation. It is pertinent to note for a tribunal that we have 2 grounds, which is separated by the word "or," which is an indication that these grounds are non-conjunctive in nature. However, for the tribunal's convenience, the council will be dealing with both of them. As earlier mentioned by the council, we have the first ground, which is requisitioning. Now, the facts of the case clearly state that when the requisition took place, no such issue was enacted by the respondent state, nor was it informed to the claimants. And even if the tribunal is ready to accept that there was no need to issue such a notice, the second part to complete a requisition is missing, which is immediate or future compensation. And as we know, no such compensation has been given to the claimants. Now, coming to the destruction of the property, this has a proviso on page 76, which is by the necessity of the situation. Now, as the council has already addressed the question of the doctrine of necessity and whether the respondents can invoke this plea, and that our submission for the claimants is that they cannot, it is our submission before this tribunal that under clause 6, clause 6.1 and clause 6.2 in particular, the claimants are entitled to compensation by the respondents with regards to the destruction of the Freya plant and the open facility. Now we come to the final ground, members of this tribunal, which is whether the claimant is entitled to moral damages. Now, this question is, to be very honest before the tribunal, a complex one. Now, there is no objective standard that tribunals may take to assess whether moral damages has to be paid. However, this tribunal may refer to the decisions of other ICSID tribunals where such a question was arisen. Now, before I get to these case laws, it is also important that at the outset, prima facie, the BIT does not mention that moral damages has to be paid. In this regard, if I may once again refer this tribunal to the BIT, specifically Article 20, which can be found on page 80, but the contents of it is found on page 81, whenever the tribunal is with me. Yes, we see on the first clause, the second subclause, restitution in kind, provided that the contracting party may pay pecuniary compensation in lieu of restitution. Now, what exactly or how exactly does this mean that moral damages have to be paid? The council would like to implore the tribunal to take a look at the word restitution. Now, what does restitution mean? The ILC articles on state responsibility has stated that restitution would mean to reestablish a situation before the injury took place. Now, what exactly is this particular situation that the council is submitting? And it is our submissions that it is the reputation of the claimant's company. Now, with regards to, once again, back to the grounds for which this tribunal may take as a persuasive value, the council would like to refer this tribunal to the ICSID case of Lemire and Ukraine, wherein two tests was provided by the tribunal, which are all non-conjunctive in nature. However, for the purposes of this proceedings, the council will first state that the state's action must cause a deterioration of health, stress, anxiety, other mental suffering, such as humiliation, shame, and degradation, or loss of reputation, credit, and social position. Now, the second requirement is that there must be a solid causal link between the acts of the respondent state and the acts of the injured party. It is our submission here before this tribunal that when the civil war ended, the investors of other industries were able to rebuild their plants, but unfortunately, the claimants were not able to do so. As a reason, because all the measures that we have taken, that is applying for a loan to the State Bank of Bravos, was rejected. Our fresh equity offers was undersubscribed, and our image as a whole took very huge damage in foreign markets. For better clarity, if I may refer this tribunal to page 92 of the case file, whenever the tribunal is with me. Paragraph 18 states that Sutton was effectively unable, my apologies, to rebuild its investments in Reykjavik due to the denial of the loan by the State Bank of Bravos. Now, in the interest of time, I request the tribunal to exercise their liberty to take note of page 18.18, wherein the tribunal will find the reason as to why this loan application was rejected, which is because of an ongoing criminal investigation that the respondents are taking with regards to the claimants. Now, what are the facts of this criminal investigation? It is that the claimants somehow are related to funding the armed militia. Now, we do not contest against the respondents' right as a sovereign to conduct such criminal investigations. However, we do implore the tribunal to check the circumstances. We are not the only cannabis players in Rekia. They had local investors that were involved in the cannabis industry, and however, we were the only ones that was investigated. And such, because of such an arbitrary, baseless accusation, the respondents have been essentially disabled to rebuild their investments once again, and therefore, the council would like to plead once again before the tribunal that first, the respondents have violated the full protection and security obligation under Article 5 of the Athabaskan Rekian BIT. Second, yes, Madam Presiding Arbitrator.
Thank you. Just two questions. One is, given the nature of the damage that you're claiming with respect to moral damages, would a declaratory relief be sufficient for the claimants? And secondly, in our understanding, moral damages are usually not granted to entities and are granted with respect to individuals because of the nature of damage, again, that is being claimed. So if you could clarify how an entity could claim moral damages.
Yes, Madam Arbitrator. I do sense that my time is up. If I may request an additional minute to answer the questions and sum up. Thank you very much. With regards to your first question, Madam Presiding Arbitrator, which is whether it will be enough for the claimants have requested $10 million to be instituted as moral compensation. Now, for the convenience of this tribunal, the council submits that this amount may or may not be enough for the claimants. However, since we are not in the quantum making stage of the proceedings, the council is more than happy to go back and consult with the claimants' experts to bring about a more appropriate sense of compensation. With regards to the second question, Madam Arbitrator, you are correct that moral damages is more often than not provided to individuals and not entities. And even if that is the case, members of this tribunal, if I may quickly refer this tribunal again to procedural order number 3, we see on page 92, paragraph 19, the paragraph reads that Sutton's employees reported being emotionally distressed by the militia attacks. Now, if the tribunal is not in agreement that the company itself must be paid moral damages, the employees at least are entitled to moral damages. With that, the council would like to rest its case. It was an honor pleading before this tribunal. Thank you very much.
Thank you, counsel. If my co-arbitrators have no questions, I would like to invite the respondents.
No questions from me, Madam Chair.
No questions from me as well. Thank you.
Thank you. So then I would like to invite the respondents to come in on merits.
Thank you, Madam President. I hope I'm audible and visible to all the members of the tribunal. Humble greetings to Madam President and other members of the tribunal. I am Rajiv Somani, co-counsel for the respondent in the case concerning Sutton Holdings Inc. versus the Republic of Rekia. As my co-counsel has already explained that the claimant has utterly failed to establish the tribunal's jurisdiction to decide the current dispute, the council would like to take the baton and proceed forward with covering the issues based on merits of the dispute. Members of the tribunal, what we have here today is a case of the claimant investor portraying themselves as a victim of a state vendetta, but clearly disregarding and even refusing to acknowledge the prevailing situations of armed conflict and civil war going on in the Republic of Rekia. The claimant, after getting a negative award in their favor, had once again initiated this infructuous case as a desperate attempt to extort money out of the respondent state. To contextualize all my submissions, members of the tribunal, I request the bench to please assess all the arguments in the backdrop of an ongoing civil war in the state of Rekia. For the tribunal's ease, the council will be mirroring the arguments as raised by my learned friend from the claimants, and thereby lay down my 3 major submissions, which are: A, that the respondent has not breached its obligation to provide full protection and security to the claimant's investments; B, that the compensation for war loss clause precludes the claimant from claiming compensation under FPS clause; and C, that the claimant is not entitled to receive compensation for moral damages. If the tribunal has no preliminary queries, the council would like to begin with the submissions. Much obliged. Beginning with my first substantive issue, members of the tribunal, the council submits that it is undisputed that FPS standard does not impose strict liability on the host state, but it is only an obligation of due diligence, that too conditioned by circumstances. Quoting the case of ICJ, the case of LC under the decided by ICJ, it was decided and noted down in the reference to this particular provision of constant protection and security. It cannot be construed as the giving of a warranty that property shall never in any circumstances be occupied or disturbed. And after this reason, the council has two broad points to submit in the FPS issue. First one being that the respondent took all the reasonable measures to fulfill its obligation of due diligence, the standard of which is set in Article 5. And second one being that even this requirement of due diligence is conditioned by circumstances. Members of the tribunal, as pointed out by my learned friend from the claimant's side, with regards to talking about the requirement of due diligence, the important fact that the claimant did not highlighted in their submissions was this civil war going across the country of Rikia. The civil war going across the country of Rikia, the council submits that because of the civil war going across the country of Rikia, the respondent had done even all of the things that were done by the respondent was done in light of civil war. With this, I would like to ask members of the tribunal to please refer to page number 75 of the case record and page number 78 of the PDF if any members of the tribunal are referring to the soft copy. Over this page number, members of the tribunal, you may find Article 5 of FPS, and the standard has been fixed in this particular article very clearly. It says that the concept of fair and equitable treatment and FPS do not require treatment in addition to or beyond that which is required by the international law minimum standard of treatment of aliens as evidenced of state practice and opinion juris. Even after that, members of the tribunal, the respondent's state sent across a large number of its most effective troops to their plant of Odin, where its authority was actually weaker than the urban centers, and still troops were placed as early as possible. This fact alone highlights the good faith on the part of the respondent. Even after being located to the west of the city of Stockhagen, that was actually occupied by the armed militia, one of the two major cities, which was captured by the armed militia, the respondent state still mobilized and sent across its military units just within 48 hours of the attack on the plant of Freya. Quoting the case of Strabeck versus Libya and drawing a parallel, the council submits that in this particular case itself, the factual situation was pretty much similar to the current case, where the authority of Libyan government was weaker and they were going through a crisis as similar to the Rikia. And tribunal noted that the respondent's obligation under the treaty to accord constant protection exists in a setting of weak and uncertain state authority, recurring armed conflict, and widespread breakdown of the law in wide areas of the country. Members of the tribunal must note that the general instability faced by the Rikia should be taken into account while fulfilling the standard of due diligence. And even after that, the case used by my learned friend claimant of AAPL versus Sri Lanka to quote the standard of due diligence should be distinguished from the current case, because in that particular case, no forces were sent at all. But in our case, we did send the forces that we had at our peril. In the circumstances, members of the tribunal that were prevailing under the Rikia, and to quote the notable investment law authors Dolzer and Schuer, even they have maintained that the standard of liability under the full protection and security standard requires a host state to take such measures to protect the foreign investment as are reasonable in the circumstances, and provided the circumstances which were that our major cities had been taken control of, our capital cities were acquired by the armed militias, and even our military was running away we had the council is admitting it is indeed true that many members of Rican military did let go of their post, and even after facing these situations, we had given all the protection. With regards to talking about,
if I might interrupt at this point, are you saying that part of the respondents' obligations to protect the investment included destroying the investment by your military forces when they left?
Thank you for this question, Madam Arbitrator. The destruction of the property came around because of the necessity of the situation that the council will be covering in the second part of his submissions dealing with Article 6 subclause 2. But to quickly answer this particular query and to answer the point of negative obligation as raised by the claimant's counsel, it is submitted that the Rican military did not directly cause the harm. The harm was caused because of the necessity of the situation that arose at that particular time. And talking about the particular point of where the claimant mentioned that when airlift of soldiers could have happened, airdrop of resources could also have happened. But what they didn't mention was that it was an emergency airlift, and we were facing a lot of protests. Other than we were also facing other problems at that particular time when we did that, and we needed that military to be to go at different places. I hope that settles your query, Madam Arbitrator. Thank you. Therefore, FPS being an obligation of means and not ends, the respondent took all the possible reasonable measures during the civil war to protect the interest of claimants' investments from attacks of armed militia. If the tribunal has no further questions, then may the council proceed with this next issue. Thank you, members of the tribunal. Members of the tribunal, my second leg of the submission is that Article 6 of the BIT prevents the claimant from claiming compensation under Article 5 because of two reasons. First one, that the principle of lex specialis derogate legi generali applies on Article 6 subclause 1. And secondly, that the claimant cannot ask for compensation under either clause of Article 6 because of non-discriminatory nature of clause 1 and necessity of the situation in clause 2. Members of the tribunal, a war clause within the same BIT as the FPS clause should supersede the FPS standard as lex specialis. The limited argument that the council would like to raise here is that the claimant should not be allowed to seek compensation twice under Article 5 and then come again in Article 6. And to that effect, Article 6 should preclude Article 5. The council would like to rely on the case of Lessie Spa versus People's Democratic Republic of Algeria. This is an exit case of 2008, members of the tribunal, where it was held that under the rule of interpretation of lex specialis, the more specific provision takes precedence over the general one. And in this case, the subject matter of both the articles is very similar. That is, to provide compensation in case of losses to claimants investments, with an only exception of Article 6 being applicable during the time of war, armed conflict, and state of national emergency. And just so it happens, that's exactly what was the case in this particular circumstances. Members of the tribunal.
Council, does Article 6 refer to Article 5 in any way?
Mr. Arbitrator, could you please repeat your question?
Does Article 6 refer to Article 5 in any express way? That you see, for instance, in Article 6, there is a reference in the paragraph 2 to the paragraph 1. But in Article 6, there is no reference to Article 5, is it?
Indeed, Mr. Arbitrator, there is no particular reference of Article 5 under Article 6. But the treaty drafters included this particular article to be used in the situation of armed conflict and civil wars that has arisen in this particular case. And that is why, in this particular regard, the council would once again like to reiterate his limited argument that the preclusion effect will only be happening with regards to the compensation. It is not the council's submission. Yes.
You yourself mentioned that Article 6 deals with compensation in really specific factual circumstances. Article 5 is a substantive protection that is offered by the community. Given that domain is so entirely different, one being a substantive protection and the other being only with respect to non-discrimination of compensation, how can we say that one is lex specialis to the other?
Thank you for this question, Madam President. To answer this question, the council submits that the respondent is not running away from fulfilling the obligation, the substantive obligation as raised by Madam President under Article 5. The only thing we contend is that compensation should not be allowed to be asked twice under Article 5 and then once again in Article 6. Moving ahead with second clause of Article 6 and talking about the term of necessity of the situation in the extended war clause, the council requests that this shall be looked in the broadest sense by this tribunal. It was contended by the claimant's counsel that we had requisitioned the property of Odin, which is untrue with regards to the facts mentioned under PO3. Referring to point number 11 at page number 91 of the case record and page number 94 of the PDF, if the members are with me. This particular point clearly mentions that the respondent did not issue a requisition for the Odin facility prior to the occupation by Rican soldiers. The requisition was only issued after 4 months of protecting the Odin facilities. From June 2016 to October 2016, the Rican military was actually there at the plant of Odin and protecting that particular plant. And even between this period, we were able to control down the armed militia for 4 straight months. But after trying their best, it was only after the military were cornered and they ran out of food supplies that they were to be ordered to destroy the buildings that could possibly be used for agricultural productions. This action was only taken to avert the unduly prolongation of the civil war. As referring to the claimant's submission with regards to asking for compensation under this particular Article 6 and subclause 2, it cannot be asked because referring to the 2 points, which is with regards to the combat action and second one being the necessity of the situation. As already distinguished, the council also submits that the plant of Odin was not destroyed in combat action, but it was destroyed because of the necessity of the situation. And if I may make a quick reference to Article 28 at this particular point of time, members of the tribunal, which can be referred at page number 83 of the case record. This article talks about the essential security interests of a state that has to be protected at any cost. And this is an exceptional article under the entire BIT, members of the tribunal. And quickly making a reference to the exit case of LG&E versus Argentina, it was noted by the tribunal in that particular case that Argentina being in a period of crisis, it was necessary to enact measures to maintain public order and protect its essential security interests. And that is exactly what the respondent did. To protect their public order and to not let the militia take over that particular plant that could have even led to that particular point, that particular area being going away from the jurisdiction of the Rican government, because as mentioned in the uncontested facts, it was very far away from these major cities of the government. And that is why the action of Rican military were not done in bad faith, and they were only executed after taking all other realistic measures possible at that time. Moreover, the acts of military were justified because they fall under the necessary measures taken by the state to achieve the objectives of to maintain public order. If members of the tribunal has no further questions on this issue, the council would like to move to the next issue of moral damages. Thank you, members of the tribunal. The council will now give his threefold submissions to refute the claim of moral damages as raised by the claimant. First one being that there is no treaty breach at the hand of the respondent. Second one being that the claimant has failed to establish a direct nexus between cause and effect of the respondent's action and the losses suffered by the claimant. And third one being that the claimant has failed to pass the exceptional circumstances test to receive the moral damages. The most basic point on which the claim for moral damages should be rejected is an absence of a treaty breach. Members of the tribunal, there is no article under the BIT which provides for providing moral damages, and there is also no article which the respondent has breached. And therefore, this particular claim should be solely rejected on this basis. And this has been held in the case of Evans and others versus Costa Rica as well. Secondly, and pointing out to the Limaya versus.
I seem to remember that the Claimants Council mentioned that the actions were arbitrary and discriminatory. I believe this could fall under fair and equitable treatment and others. How do you respond to this?
Thank you for your question, Mr. Arbitrator. The point raised with regards to the actions being arbitrary are only a following of due process of law. If members of the tribunal may please refer to page number 21 and paragraph number 5. If the members are with me. This particular paragraph, Mr. Arbitrator, clearly mentions that RICA was committed to investigate all individuals suspected of involvement in paramilitary groups, and upon concluding its findings, will prosecute such individuals to the fullest extent of the law. And as state being the sovereign entity had some doubts with regards to the claimant's involvement in the in this particular issue, they were prosecuted. Moreover, the bad faith element can also not be asked, cannot be said to be fulfilled, because we were the one who initiated negotiation with the claimants. That can be seen at point number 21 of PO3 at page number 92. I believe, members of the tribunal, I am running out of my time, so I request you to please extend. Please give me an extension of 60 seconds to complete my arguments.
Sure.
Thank you, Madam President. As I was saying, the claimant has failed miserably in proving that there is any bad faith on the part of the respondents. And secondly, they have also not fulfilled the exceptional circumstances test, because it is a known principle that a party claiming moral damages has to fulfill the gravity requirement, threshold of which is very high. In the present case, the threshold becomes even extraordinary because of the prevailing situation of civil war in RICA. And this particular exceptional circumstances test that has been referred to by the Claimants Council in their submissions can also be refuted with the help of, because these criteria were written in the absence of and without taking in account the civil war. And in this case, as the civil war was prevailing, it should be understood that the circumstances that were prevailing in the state of RICA were the reason that the claimant cannot fulfill the high gravity of their losses and cannot relate it to with the respondent's actions. Therefore, the claimant's claim for moral damages should be rejected because of not meeting the high threshold and for lack of sufficient evidence to suggest that the respondent's conduct was malified. It was a pleasure to argue before this bench. Thank you, ma'am.
Thank you, counsel. Thank you. If my co-arbitrators have no questions, we can move to rebuttals and rebuttals.
No question from my side.
No questions, Madam Chair.
Then I invite the claimants for any rebuttals they may have.
Greetings once again, Madam Presiding Arbitrator and members of this tribunal. The council would like to submit a one-pointer rebuttal. My learned opposition counsel has relied heavily on bad faith and how we have failed to prove so. In this regard, if I may once again remind this tribunal that the respondent counsel has not yet addressed as to why the request sent in 2014 by the CEO of the claimants was not responded to. In addition to that, request for meetings in 2015 was also not responded to. And in 2016, for lack of a better phrase, to add insult to injury, Mr. Rokhari, the Home Minister for the respondents, held such a consultation meeting in 2016 with their own investors. And in the interest of time, I would request the tribunal to exercise their liberty to refer to paragraph 8 of page 29 to find the same. Thank you very much once again, members of the tribunal.
One question, counsel, here. Is bad
Yes,
faith a
exactly.
condition for FEPS to apply full protection and security?
My apologies, Mr. Arbitrator, if you could please repeat.
Is bad faith a condition for applying full protection and security?
Certainly not, Mr. Arbitrator. It is, as stated, a relatively low standard. The bad faith is with conjunction of the moral damages claim.
Thank you.
Thank you very much, Mr. Arbitrator.
Thank you, counsel. I request the respondent to come in with the rebuttals if you would like to respond.
Thank you, Madam President. I only have 2 points to reply to my learned friend from the claimants. First one being that the letters that were sent by various industry holders and various industry leaders of cannabis were duly taken note of. And for this, I would like to refer to paragraph number 10 at page number 29 of the emergency prayer statement, where Mr. Anthony Ricari has said that I emphasize this to reassure our partners who have invested in Rikia's fledgling cannabis industry that our concerns have been seriously and carefully noted. And secondly, with regards to this particular point only, members of the tribunal, it is to be noted that it was not only the cannabis industries that were under attack. The rioting and the event of civil war had very large scale repercussions, and we had to save our citizens as well. We had to manage with finite resources and infinite problems, and that is why the element of bad faith cannot be established. Lastly, other buildings were also affected, so it cannot be said to be a bad faith. Thank you, members of the tribunal.
Counsel, what do you mean by carefully noted? That the letters were noted. What does this entail?
Indeed, Mr. Arbitrator, this means that all the concerns of all the cannabis industry holders were taken duly note of, but the timing of civil war precluded Mr. Anthony Ricari from meeting each and every industry holder in that particular regard. But as mentioning to this particular paragraph 10, the issues were definitely noted and we also acted on them.
Thank you.
Thank you, Mr.
Thank you, Counsel. I believe this brings us to the end of this hearing. Thank you to my co-arbitrators and to the counsels.
Thank you. I will